Everyone to the latest in our lunchtime webinars on commercial topics. More participants coming through. But today we have myself, Fergus McCombie, and Carol Cheng. And we are speaking about business continuity, and particularly with a focus on the insolvent context. So we're going to be talking about Phoenix companies. We're going to be talking about risks for directors in the insolvency context, both on and after an insolvency event. And we're going to be talking for about probably 45 to 50 minutes. Let's see how we go. You are very, very welcome to ask questions as we go, and we will pick those up as and when we receive them. And there'll be some time for questions at the end as well. So whenever something arises, please do put a question in the chat, and we will do our best to deal with those as we see them. There may be some that we leave to the end, but let's, as I say, let us see how we go. So Carol is going to take the first section of today's webinar. Before I hand over, what I'm going to do is share our slides. Now, this is obviously the point where it all goes wrong. But I'm going to share my screen, and hopefully that will mean that everyone will see the slides. Excellent. So just for my own peace of mind, Carol, can you see the slides on your screen?
Yes.
Thank you. Right, so I'll hand over to Carol, and we will make a start.
Thanks, Fergus, and good afternoon, everyone. Thanks for joining our webinar. As Fergus said, if you have any questions, just put them in the chat and we can deal with those after. So my talk will be focusing on Phoenix companies, and broadly I'll be touching upon what this is and what some of the common concerns with it are, the rules that apply to any director or shadow director of a company in the 12 months before it goes into insolvent liquidation, and also the relationship between Phoenix companies and prepacts. So Fergus, if you could just go to the first slide, please. So first of all, what is Phoenix trading? So this is where the assets of an insolvent business are reacquired, often at less than their full value, by the former directors or closely connected parties of the company, who then set up a new company which is involved in the same or a similar business. And that new company is what we call the Phoenix company or NewCo. And the directors and shareholders of a limited liability company normally don't retain liability for the company's debts if it becomes insolvent. So in effect, having this Phoenix company arrangement allows a business to start again and for the profitable elements of the failed business to survive. And this offers some continuity for both employees and suppliers of the company. Most Phoenix companies are legitimate businesses. Not all businesses succeed at the first time. So businesses can fail for a number of reasons. They can be dissolved or face financial difficulties for reasons apart from misconduct. And for the most part, it's not illegal for directors of an insolvent company to form a new company from the remnants of the failed company. And they can become the new directors, except in a number of situations that I've listed there. So firstly, if they are adjudged bankrupt. Secondly, if they're subject to a disqualification order or undertaking. And thirdly, if they're subject to a bankruptcy restrictions order or undertaking. There are, however, some common concerns with Phoenix trading. So creditors can often be aggrieved to find that the directors of an insolvent company may suffer little personal loss and are able to set up a new business in the same field. Creditors can also have concerns that directors have deliberately forced their company into insolvency in order to buy back the business assets at a reduced price, whilst avoiding responsibility for the company's debts. However, we have the Insolvency Act 1986, which imposes some rules that make it far more difficult for directors to do this. And it does that by imposing some strict rules over the insolvency process. And we'll look at some of those rules in a second. Fergus, if you could move to the next slide, please. So in terms of the legality of Phoenix companies, as I said just a moment ago, it's not illegal to start up a Phoenix company following the liquidation of the original company, but there are some rules that have to be followed. And those rules are designed to prevent directors from deliberately running a company into liquidation, leaving unpaid creditors, only to set up overnight a new business trading under a similar name to that of the liquidated company. There are three main rules that govern the situation of Phoenix companies that I'll talk you through. So the first one of these is restrictions on the use of a company name. So the significance of a company name is that in many corporate insolvencies, the company's brand is a key asset. It is or may be a key asset for a prospective purchaser. And so you have some rules under sections 216 and 217 of the Insolvency Act 1986, which introduced restrictions on the reuse of insolvent company names. And this is intended to prevent creditors of old co from incurring further losses by dealing with new co in the mistaken belief that they're still dealing with old co and in ignorance of the fact that old co is now liquidated. So the rule basically is that if you're a director of a company at any time in the 12 months before it goes into insolvent liquidation, you're banned for 5 years from being a director of or of being directly or indirectly concerned or taking part in the promotion, formation, management, or carrying on of a company with a prohibited name. In terms of what constitutes a prohibited name, this could be the liquidated company's registered name at any time in the 12 months before liquidation, or any other name that the liquidated company was known by in those 12 months prior, including any trading names, or also any similar name that suggests an association with the liquidated company. Now, this is a strict liability offense, but there are a few exceptions that are set out in the Insolvency England and Wales Rules 2016. So the first one of these exceptions is that if there's an arrangement with the liquidator to acquire the whole of the business of the insolvent company, and before using the name, you give the requisite legal notice in the Gazette and to all creditors. The second exception is if throughout the 12 months prior to liquidation, the new company with the same or similar name has been known by such new name continuously and has not been dormant. It's important to note that this exception only applies to companies and not unincorporated businesses. The third exception is if you apply to court for permission to use the prohibited name within 7 business days of liquidation, in which case you can use that prohibited name for either up to 6 weeks from liquidation or up to the point where the court decides to give you permission if that's less than 6 weeks. And in terms of whether or not the court will grant that permission, it has wide discretion and will look at a number of factors, including whether the relevant person is responsible for ODCO's demise, if there's any evidence of misconduct, the value paid by NewCo in any acquisition, and also on the risk to and also awareness of any affected creditors. The court only has 6 weeks to make its decision, and if it hasn't made that decision within 6 weeks, then the ban will again apply to you. So that's the first of the key rules I want to touch on. Fergus, if you could move to the next slide, please. The second one, which I'll only touch upon briefly, is about ensuring a legitimate sale of company assets. And this is to do with the way in which the company is valued. So if a director of an insolvent company wishes to sell assets to a new company which he's connected to, then he's expected to obtain a proper independent valuation of the company assets before sale. So in order to avoid any challenges to the legitimacy of property transactions to connected parties, the assets should be sold at the higher valuation. I've set out there the three key ways in which the physical assets can be valued. I'll only touch upon this briefly, but you have a forced sale, which is the expected realizable value of the assets if they're sold quickly at an auction. And because of the speed at which the sale occurs, typically this would result in lower compensation. You also have an open market sale valuation, which is where there is less urgency and you assume a willing seller and a willing buyer. And so you're more likely to obtain a fair price. And then also there's the value to the business, which reflects the specific worth of the asset to the owner. And that typically focuses more on capacity to generate cash flow rather than just resale price. So that's the second of the key rules. If we could go on to the next slide. The third one that I want to touch upon is transactions that may be set aside. And there are two key ones. The first one is preference transactions, and the second one is transactions at an undervalue. So there may be grounds for having the court set aside disposal of company assets transactions. So on either of these two grounds, provided that the transactions were entered into at a time when the company was unable to pay its debts. So firstly, with preference transactions, this is where the transaction places a creditor in a better position if the company subsequently becomes insolvent than if the transaction hadn't occurred. So if the transaction occurs within 6 months of the company's insolvency, then you can apply to the court to have it set aside. And the court has to be satisfied that the directors, when entering into the transaction, were influenced by a desire to produce that preferential effect. Where you're dealing with a creditor who is a connected person, so that's any of the company's directors or shareholders, that 6-month period is extended to 2 years. And the court will also presume that there's a desire to prefer the creditor unless that presumption can be rebutted. There are a few principles to point out. So this desire to prefer test is subjective, and it's assessed at the time of the decision to make the payment and not just the point at which the payment is made. Also, a desire to prefer is not proven merely because a creditor is paid. A payment may not be a preference if it's made due to commercial pressure, such as threat of legal action or desire to secure future supply, or if the director genuinely believed that all creditors would be repaid. So that's preference transactions. If we then move on to the next slide. So as I said, the second category of transactions that may be set aside is transactions at an undervalue. So this occurs where a company disposes of its assets for no consideration or for consideration where the true value is significantly less than the value of the consideration provided by the company. And you have a 2-year period post-insolvency to make that application to the court to try and have the transaction set aside. And the recovered assets would then instead be used for the benefit of the creditors. I've put on the slide there a recent authority, which is called Al Husseini and Investment Bank. This is a 2025 Supreme Court case, which represents a recent development and also expansive interpretation of the term transaction. So this case was actually dealing with a different category of transactions. It was dealing with transactions intended to defraud creditors, but in the judgment, the Supreme Court also addressed undervalued transactions. And the Supreme Court adopted a broad interpretation of transaction so that this applies even when the asset transferred was not directly or beneficially owned by the company. And what this means is that directors can't avoid liability simply by using a corporate entity to transfer assets that they don't personally or directly own. So that's the legality of Phoenix companies. If we then move on to the next slide. I'm also now going to just touch upon the relationship between Phoenix Trading and pre-packs. So I've set out in that table on the slide some of the key differences between the two processes. So firstly, pre-packs are typically a one-stage process where you organize the sale of the assets before an administrator is formally appointed, and then the business is sold in one go to a third party, or new co is formed by the directors. This is to be contrasted with the Phoenix trading arrangement, which is a two-stage process where you first establish the new co and which begins trading, and then you have the original company enter into liquidation, and its assets are then realized and purchased by the new co. Also, the way in which the assets are realized is also different. So with pre-packs, you focus on rescuing the business via administration rules, whereas with Phoenix trading, you realize assets as part of a formal winding up process. And then you also have different individuals who are running the process. So with pre-packs, it's run by an insolvency practitioner, whereas with the Phoenix trading arrangement, it'll be run by the original directors. If we could just then go on to the next slide. So the key attraction to using pre-packs is its speed. So the speed with which the administration proceeds. Pre-packs aren't formally provided for in any insolvency legislation, but they've arisen out of practice and through judicial approval. And the decision to execute a pre-pack sale is a matter for the commercial judgment of the administrator. In terms of the involvement of the creditors, secured creditors are normally involved because they need to consent to the release of their security, where any secured assets are to be included in the sale. By contrast, unsecured creditors often don't realize that a pre-pack sale is going to happen, and so they don't have the opportunity to protect their interests by considering and voting on the pre-pack proposal. And this means that the administrator could sell company assets before the proposals have been agreed by creditors and without court sanction. So a concern that unsecured creditors may have is that company assets would be sold at a reduced price, or that the goodwill of the business may not have been properly valued because of the speed in which the sale is occurring. In order to address these concerns, you have the Statement of Insolvency Practice, SIP 16, which outlines the information that the administrator must disclose to creditors within 7 days of completing the pre-pack sale. And it also sets the standards by which the administrator has to adhere to both before and during the administration. This isn't legally binding, but failure to comply with it could result in an administrator facing regulatory or disciplinary action. So that's my last slide. That's my talk. I hope that's been a helpful overview of Phoenix trading, what it is, the common concerns with it, and the key rules that are in place to regulate it, and also its relationship with pre-packs. Like I said, if you have any questions, feel free to pop them into the chat, and then I'll pass on to Fergus.
Thank you very much, Carol, for that. There's Carol's profile, obviously available on our website. And I think, Carol, you've been particularly interested in international work over the last few months. Been off to Dubai, I think. Is that right? So there's another string to Carol's bow. As far as today is concerned, I want, first of all, to talk a little bit about the impact of TUPE. Now, obviously, in Phoenix situations, one of the considerations is going to be, well, who do we keep? Who do we get rid of? How do we manage the workforce? And those types of questions. There are various difficult issues surrounding that, and it so often goes wrong that it's worth reminding ourselves of what the regime is. So in the ordinary case, TUPE operates to preserve the continuity of employment of employees, and it's a protective measure derived from European legislation designed to achieve certain comfort for at least so that some people can be kept on. Contracts of employment and continuity will be preserved automatically. So there's an automatic transfer of contracts under Regulation 4 on a change of ownership or a service provision change. That can be, importantly, a contractor taking over a contract. So I've recently advised, by way of example, on a transfer of a client team servicing social media output for a gaming company. Neither side contemplated that actually they might want to be taking over or might need to be taking over the client service team from the first contractor. And so this causes difficulties when you then realize that the first contractor wants to divest itself of certain employee liabilities and responsibilities. So it can apply in that context as well. So as I say, Regulation 4 operates to transfer automatically those contracts of employment. The advice for a transferring company, if it's getting rid of a team or if a new contractor is taking over a service provision, if all else fails, if there's going to be a conflict, just in brutal terms, the advice is dismiss them before the transfer so that the liabilities are reduced. Because if you don't, that regulation will operate to transfer contracts automatically. But Regulation 7, if a transfer does occur, will preserve the essential rights of employees, including the right not to be dismissed because of that transfer. So by then it's too late. Now, in the insolvency context, we have provisions in TUPE, Regulation 8 specifically, that disapply that impact where insolvency proceedings have been opened with a view to liquidation. So when that type of insolvency proceeding is opened, Regulation 4 and Regulation 7 don't apply at all. There's no claim for unfair dismissal, and the tab for redundancy is left to be picked up by the Secretary of State. If the company is in administration, however, under Schedule B1 of the 1986 Act, that is clearly a situation in which liquidation is not contemplated, at least in respect of the transfer of employees, it isn't contemplated. And that doesn't fall within that saving provision. So on that scenario, employees will transfer, and the administrator needs just to be very cautious about the way in which those employees are dealt with, because they have a right to be informed and consulted. So what's the difference in case law? I've already referred to Schedule B1, but recently we have the case of, this is from November 2025. Is that on the next slide? There you go. So the first bullet, that's where we are. Transfer provision of protection for dismissal do not apply. There's a Sahonta case, that's from November 2025. Essentially, the point is that the idea that liquidation is the type of proceedings, of insolvency proceedings that are an issue, includes the appointment of a provisional liquidator. So in that case, a bakery business got into difficulty. It had a buyer, but that buyer, there was only a conditional agreement in place to transfer the business and the assets. Nothing was signed at that point. The buyer didn't initially proceed. HMRC filed their winding up petition, and a provisional liquidator was appointed at the beginning of March 2023. All employees dismissed at that point. Later on, the business sale went ahead. Later on in the same month, business sale went ahead, and a load of the employees that had previously been dismissed went to work for the new business. The Secretary of State disputed that those claimants who had the gap of continuity, and also those who've been dismissed and remained dismissed should be able to bring claims upon the National Insurance Fund. Answer: no. There had been a transfer with a view to liquidation, even when the provisional liquidator was appointed, and even in the context of the subsequent continuation of the business. So, as I say, the advice is get rid of them at the earliest possible stage, which can get away with it. Even if you take them back on later, liabilities disappear, under TUPE, that is. So, just finally on employee liabilities, even if you've transferred them over under the administration of pre-PAP, for example, there is still the opportunity under Regulation 9 to renegotiate terms and conditions. There's always that ability under TUPE, but the context has to be the connection with the transfer that really involves a reorganisation. So that does require, again, careful thought about how it's dealt with. Moving on then to restrictive covenants. I encounter requests for advice on a fairly frequent basis where people think, directors think, senior employees think that their covenants have disappeared just because there's been some kind of sale of a business or previous shareholder agreements no longer apply. I'm thinking particularly here of the scenario where part of a business is hived off. So you've got a sale of part, or you've got a shell company left behind that still might want to trade in the future, but senior management and directors have transferred across to a new business. So the question is, in what context will covenants due under a shareholders agreement or previous director service contracts still be enforceable and survive a business sale or a Phoenix company or a part sale of a business? So the standard position is, as you will all know, that restrictions contained within restraints of trade contained within any agreement are only enforceable if they're known wider than necessary to protect legitimate business interests. And you might have, when you're trying to keep a senior team together, or if part of a senior team has fled the nest, you might have covenants not to use confidential information. Those can normally be protected on the basis that if information is confidential, it's confidential. But you'll also have non-solicitation, non-compete, and non-dealing agreements, and those are harder to uphold because public policy says you shouldn't be able to restrain any form of competition. So it is relevant to compare, in the context of this talk, the employment context, where covenants of that sort can be difficult to uphold, with the shareholder and business sale context, where the law says that they can be significantly easier to uphold. So Tom James is a relatively recent case from 2025 in the employment context, where ultimately the High Court said these covenants are too wide and they can't be enforced. Tom James was or is a tailoring business, a US tailoring business, essentially. And one of their tailors, who was partly responsible for maintaining client relationships, went off to work for a competitor. Now, there's no insolvency context here, but this will continue to be relevant in a scenario where you've got part sales of a business or part sale of a division, which means that in a business context, that division will continue to operate under a different name. The question is whether those covenants can be upheld. But in the Tom James case, those restrictions went further than they were reasonably necessary to protect legitimate business interests. You very often have a mix of covenants, but in that particular case, the 12-month non-compete was thought to be too long, and the lack of geographic limitation was thought to be overextensive. So in the context of somebody just responsible within the UK for maintaining client relationships in the employment context, those kinds of covenants are likely to be too wide. But in the shareholder and business sale context, that's not going to be the case quite often. So Kinixa is I find one of the best cases. It's 2008, so it's not particularly recent, but it's one of the best cases for explaining the distinction, because it specifically deals with the distinction in quite a clear, beg your pardon, in quite a clear and focused way. In that case, a team of directors had a mix of non-competes in employment contracts and also later on by way of their shareholder agreements. The shareholder covenants were more onerous, particularly the duration of the non-competes. So in the employment contracts, it was 6 months. In the shareholder agreement, it was a 12-month restriction. They took up roles with competitors, and therefore, the employment contract covenants in the strict sense no longer directly applied, but the shareholder agreement covenants did remain. So the question then arises, when you've got those shareholder agreement covenants and arguably supervening employment covenants that might survive termination, which is the right approach to take? Now, there's a specific finding in that case that the longer period under the shareholder agreement covenants wasn't unreasonable when entered into, because that 12-month restriction under the shareholder agreements was reasonable to restrict the competition or govern the loyalty that a shareholder might be expected to have. So this is true even though they've gone off to work for separate businesses. So in shareholder agreements, I've seen durations of 2 years and more, and the temptation, and I think usually the right advice, when you've got a mix of employment covenants and shareholder agreement covenants, is that if litigation is threatened, shareholder agreement covenants are enforceable enough to be upheld by a court considering a interim application. And I say enforceable enough because the applicant for an injunction, or the potential claimant for a claim, at that interim stage only needs to show that there is a real issue to be tried, and that the balance of prejudice is in favour of keeping the restriction, at least until trial. So if you've got something in a shareholder agreement, that's generally likely to get over that test. Even if at trial, even a shareholder agreement at trial, if you can show on all the facts, throwing it all in, that actually there's some problem with duration and enforceability and over-extensiveness of the shareholder agreement clause, it's enforceable enough. So that's always the danger and the risk at the interim stage. And you have to be able to justify very, very clearly why a restriction of 2 years is enough. In Kinixa, it was enough, but of course that's fact specific. The other interesting feature of the Kinixa case is something that, again, I'm sure you will all be aware of. It's a reaffirmation that it's a breach of fiduciary duties and the duty of fidelity for senior management approached or contemplating a move to another business not to disclose discussions with a competitor. Now, again, of course, that's fact sensitive, because you don't have to disclose every single discussion. You wouldn't have to disclose pub talk when you're going to come and join us. But if there are steps that are taken which really are with a view to joining, or how a business would work when a shareholder leaves and sets up their division with a competitor, then the fiduciary duty and the duty of fidelity is engaged with your fellow shareholders, with your fellow directors, with the previous business, to disclose those discussions. The other feature is a reminder, which, again, something very often missed by clients. If you email yourself confidential documents with a view to a move, with a view to setting up in competition, either on your own or with a competitor, it's highly, highly likely to be a breach of your confidential information clauses. And because they are documents and because they're confidential information, it's much harder to argue that there's a judgment call and there's a balance and all this kind of stuff. There's no real prejudice. The fact is you've taken documents from your current company, so that's very often going to be a breach. So those are the kinds of issues and risks that present themselves to senior management looked at from the perspective of old business and setting up with a new business, either because you're worried about impending insolvency and you want to fly the nest, or because you just think that actually you're better off somewhere else. In that same context, moving on then to some other types of risks for directors, and the first one I want to mention is the sorry, just while I sort my screen out, there we are, is the interest of creditors. And we have the Sequana case from a couple of years ago now, but it's a good one to understand directors' duties more fully in a pre-insolvency context. For some commentary, this Sequana case was a surprising result, but actually it's so well unexplained that it really repays close reading about what the duties might be for directors in that kind of context. This is about a company director's duty to act in good faith and in the best interests of the company at all times. There's a common law rule that those interests sometimes and in some circumstances arise prior to insolvency, but including a duty to consider creditors' interests, to give those creditor interests appropriate weight, and to balance those interests against shareholders' interests in some contexts. Those kinds of contexts obviously involve potential conflict between shareholders' interests and creditors' interests, but the ratio of the case is that that conflict can only arise when insolvency is a real risk and not a remote risk that might happen sometime in the future. The Supreme Court thinks that the duty is preserved in the Companies Act under Section 172. So the issue on the facts in that case was about the distribution of a dividend to the company shareholder, which was distributed at a lawful time and in a lawful manner when the company was solvent, but had long-term liabilities, contingent liabilities, which gave rise to a real risk, not necessarily a probability, but a real risk that there might be an insolvency event at some date in the future. Actually, the company only went into insolvent administration 10 years later. And the issue arose because a cabal of directors thought that there'd been a breach of the duty to consider interest of creditors at that prior dividend issue point before 10 years prior. So this is surprisingly hard fought given those facts, and when you put it like that, it seems obvious, but actually it spells out the test, and it's spelled out in the High Court and the Court of Appeal, that the duty to consider the interests of creditors was triggered when the directors knew or ought to have known that the company was insolvent, and that insolvency risk in the future, even if it was real, and don't forget that liabilities might sit there on your balance sheet for a long time and look massive, even if you get extensions and are able to negotiate well with creditors, as happened in this case, the insolvency event might only occur several years down the track. But at the point that you're looking at it, when they're first on the balance sheet, it might look disastrous. Well, that's not the trigger of the creditor liability. You don't hold the creditor duty over the head of the directors for that entire period of time. That's the effect of this ruling. So unless the insolvency event amounts to a probability rather than a risk in the future, you're okay. So just a couple of other points on this. The Supreme Court made it clear that creditors always have an economic interest in the continuing solvency of the company, so it can pay its debts. You weigh that interest against the shareholders' interests in the value of the company, but the timing of that, as I've said, depends upon there being a real risk. That duty can apply to the payment of a lawful dividend in principle, but just on the fact whether it does, that is the question. The duty is to consider the creditor's interests, giving them appropriate weight, balancing them against shareholders' interests. So it's a balancing exercise, makes it very, very difficult to judge exactly when you're going to be in the wrong, but that's not unusual. There was a subsidiary question about whether shareholders could or directors could ratify a transaction even if it would jeopardize the company's solvency. And that just comes down to whether directors did in good faith in doing so or not. So the duties have been to have regard to creditors and to the company and the shareholders' interests have been rationalized in Sequana in a way that at least makes it clear what the tests are, even if it doesn't particularly make it clear how you might apply the facts to that test. Typical, as we know for English law. The second issue I want to touch on is transactions at an undervalue, and there's a TUPE case which is again pretty recent, which says that when you're considering transactions at an undervalue, the approach is a purposive one, rather than objectively whether there's just a connection between transactions. So the facts are complicated in TACA, and they're to do with companies having an interest in an oil field, and the vendor writing off defined benefit pension scheme value. The argument was that a dividend had been declared which was undervalued by reason of that write-off. The question of whether there was a transaction globally was fact-specific. And here, a dividend had only been declared after a sale had been agreed under the commercial agreements about the oil field. So it's essentially on that basis that it said that the transaction wasn't at an undervalue, because taking a purposive approach to the reason for the dividend at the time it was declared, a mere connection between the dividend and the write-off of pension value was insufficient to establish the purposive interpretation of that particular dividend. So that rings bells about the defence under Section 238 of the Insolvency Act to whether a transaction is entered into at an undervalue. And that's if the transaction is entered into in good faith for the purpose of carrying on business, and there are grounds for believing it can benefit the company. In principle, issuing a dividend at a time before a sale, even if it looks highly likely that a forced sale would be required, as in this case, could meet the test for that defence. So those are a couple of risks pre-insolvency, and then risks post-insolvency. There's I think it's a pretty interesting case from last year. This is Mitchell against Sheikh Mohammed, about continuing duty owed by former directors, and that is a topic, the question of duties held by former directors, which is apparent from the words of Section 172, but very often forgotten. So in Mitchell, the facts were that there was a dispute between the joint liquidators of the claimant company, MBI, and Sheikh Mohammed, to do with the transfer of shares by the company back to their original holder, but after the time when the sheikh had ceased to be a director of the company. The liquidators sought to recover the share value. The shares had originally been acquired as part of a series of transactions designed to facilitate an IPO. The IPO never happened, so the consideration for the shares was never paid. And so the sheikh thought, well, I'll just give them back to their original donor. So the issue was whether, as the liquidator said, the sheikh had breached his director's duties by effecting the share transfer after, in fact, he'd ceased to be a director. Of course, given that he'd ceased to be a director, the issue that arises is whether his fiduciary duty continues. Answer is yes. Supreme Court made the obvious point: former directors can still owe fiduciary duties. The question was whether the sheikh had actually breached those duties by acting dishonestly and in bad faith, and the Supreme Court upheld the Court of Appeal, saying yes, fiduciary duties can arise on an ad hoc basis, relate to one specific transaction. The sheikh had assumed a fiduciary power, even though he hadn't been appointed at that stage and lacked legal authority. And the effect was to deprive the company of the value of the shares. Now, next issue is, how do you value those shares if in fact IPO never takes place and essentially the shares have become worthless? So a question of calculation. Equitable compensation in that case calculated on the basis of the assets when the shares were originally transferred. So the relevant date is when the breach has been committed, rather than what happened later on, making them worthless. So that's equitable compensation and how it's treated in that context. And then the second point here is about penalty clauses. And I think case MacDessie is quite an old case, the Cavendish case. So I'm sure you all know about it. But it's quite entertaining on some of these facts. There are two linked appeals. The Cavendish appeal related to clauses in a share sale agreement, and the connected case, which is called Beavis, is to do with parking charges, parking charges. So I parked in a car park recently at actually a Chambers event, and I got a letter from Parking Eye referring to this Supreme Court case and saying, well, the Supreme Court have found that parking charges aren't a penalty clause. I was tempted to write back and say, yeah, but you didn't say in the car park that I couldn't park there. And giving them chapter and verse, I didn't do that. I just phoned up. So anyway, so on the question of whether there's a penalty clause in the first place, and this is really what causes the issue in this appeal. It is the clause, the penalty clause in the first place. The purpose of the law is to prevent a claimant recovering sums of money which don't bear any relation to the actual loss suffered by a claimant. So one can easily see how in a business sale context you might have clauses which specify loss in the event that covenants aren't complied with, or warranties aren't met, or certain hurdles aren't reached, either on an insolvency event or not, but specifically when a part of the business is taken over. So the Cavendish case succeeded, or the appeal succeeded. So Cavendish succeeded, the claimant succeeds on the basis that in reality, the clause of consideration is a price adjustment clause. So there's a legitimate interest, Supreme Court says, in observing covenants which exist in sale agreements. And if there's a price adjustment by reason of loss that could be suffered from breaches of share sale clauses, then that's a fair loss to recover. It's not a penalty. In the parking case, the parking charge had the objectives of managing efficient use of parking space and operating the scheme to make a profit, which were perfectly reasonable. So there's a distinct difference. The parking case relates to the objectives of the clause. The Cavendish case relates to price adjustment, so legitimate recovery of loss. Now, in a business context, it's quite easy to see how you could potentially rely on both those kinds of aims, both those kinds of justifications for what otherwise might be characterized as a penalty clause.